better that we have a discussion.
Okay. So we're live. Good evening, everyone. Welcome to another session of Mentor Arc hosted by Lawyered. Today's topic is corporate law practice, an overview, things that you as a legal aspirant should know. Today with us, we have special guests, Sowmya Parasuraman. Sowmya ma'am, welcome. Sowmya ma'am is the proprietor of Sowmya Associates, Chennai. Ma'am finished her BCom LLB from the Nagpur University and has been practicing for about 9 years. Ma'am is an established corporate lawyer, a company secretary, and IPR attorney. Sowmya ma'am is also a board member of the South Indian Regional Council of the Institute of Company Secretaries in India. Ma'am, welcome. We are very pleased to have you on board.
Just a moment.
Faculty member.
Yeah, faculty member, not a
Faculty
board
member.
member.
My apologies.
No,
Welcome,
that's
ma'am.
fine.
We are very pleased to have you for this talk. Just before we begin, I'd like to remind all the audience to please keep yourselves on mute. We would like to hear only Sowmya ma'am during this presentation. And if you have any questions at any point of the PPT, please message them to me, and I will be addressing them and bringing them forward at the end of the presentation. Thank you, ma'am. Please.
Yeah, thank you, Sami. Thank you so much for the introduction. Yes, good evening, everybody. So today we have a session on corporate law practice. So stage by stage, we'll be going to the actual subject, and I'll be also letting you know what are the advantages you may have as a person. If you have some personality traits as well, how it can help. Because see, when you talk about qualifications, when you say that I'm a law graduate, there may be so many people who have done it. So there are certain aspects which you need to work on so that you can stand out in the crowd. Okay, so to start with, we have to understand what is corporate or what is corporate law. So why so much of emphasis on the corporate sector as of now? Now, the thing is that corporate as such, or a corporate sector in India is not very new as such. It has been there for a very long time. We had 1956 Act before, and now we have 2013 Act as well. So before that also there were different enactments which dealt with the same corporate body, that is a company. But then today in the emerging scenario, things have changed a lot. And now why the change is happening is because the world as such is shrinking. And because of that, there are no boundaries. Now we are thinking in terms of boundaryless trading, boundaryless transactions. And that's why so many other countries or even investors are interested in India. And India definitely is blessed with very good climatic conditions, very good skill set so far as the human resources concerned, quality human resources, and also the investment. It's a growing sector basically. And because of this, we are seeing that day in, day out, the corporate sector is evolving in India. All over the world it is happening. In India specifically, it is more so because more people are becoming conscious that they can do more, and they are working on their own innovations, ideas. And in fact, even what you call your government is also supporting such initiatives. So it is an emerging area. And when you say it's an emerging area, automatically the legal compliances are also coming into the picture. And when you say legal compliances, it goes without saying that our sector or the legal sector or the professionals who are into law are going to have a lot of scope and opportunities. That's why you'll see that the profession of lawyers, which was the kind of profession, say before 20 or 30 years, it was entirely different from what it is now. Now the opportunities have opened up a lot, and there are many kinds of specializations. There are many areas wherein you can specialize, and it is entirely a new world. The corporate world is a new world as such. It's not an area, I would say it's an entirely a new world, which to which you can in which you can explore for more possibilities, and you can even create your own what you call path in it, like thinking on innovative lines. Now say we have the way we have legal journalism, or some kind of online legal advisories. All these things are coming up a lot. Okay. So now to understand what is corporate sector is a very important sector in India because it contributes around 53% of the GDP. And what does it involve? Now, there are many things which are covered under the corporate law practice. And if I start putting a list for that, it will be a very, very long list. So we are only using an inclusive list rather than an exhaustive list. So which includes litigation, as you know, compliance, this also you know, mergers and acquisitions, contract matters, international trade issues, and taxation. So these are all terms which you are well versed with. You already know what they are. But so far as the law students are concerned, the one of the issues that law students, which even I faced when I was doing my law, is that when we complete our law, we are not aware which is the area that we have to enter into. The reason is that we have a overall understanding of the subjects, overall understanding of what do you call interpretation, jurisprudence, everything is there, but we don't know exactly what is the in-depth analysis which is required and what our inclinations are. So this is where you have to be careful while selecting an area for yourself. You have to understand that this you have to analyze and understand what does that area require, what is the specific emphasis that area deals with, whether I have some kind of specific inclination for this area, and if I find that this subject is dry, do I have any other options? So these things have to be, of course, I know that students at this point of time, it will be difficult for them to make out which is the area best suited for them, because you need around 1 to 2 years to understand even that, which is the area which suits you. But fortunately, the profession is such that you don't have to say goodbye entirely to some particular area in order to say, welcome another area. So you can gradually navigate in such a manner that you maneuver from one area to another and deal both the things. And if you find one of them more interesting, you can concentrate on more that particular area which you are interested into. Okay. So while coming to corporate law practice, again, I'm repeating the same thing, that corporate area is a very wide area wherein there are many areas, options available. There are many opportunities. There's no dearth of opportunities at all. And again, you have to understand one thing, that as I see corporate law is that it is not saying goodbye to your CRPC practice or CPC practice or any other thing. Okay. When we say corporate law practice, we are saying only that my particular client, whoever I'm dealing with, is a corporate body. That is what it means. Now, this corporate body can have criminal issues, CRPC issues, it can have civil issues, it can have compliance issues, it can have Fema or RBI issues, it can have anything. Possibly the only area which may be left untouched may be the family matters, say for instance, divorce or alimony or maintenance may get left out, but rest of the areas are going to be there. So it doesn't mean that when you're saying that you are into corporate law practice, you are saying goodbye to any of the other areas. Be it a transfer of property, be it your ordinary contract, everything has to be there. And the good news for law students is that because they have already studied these acts, so they have a better understanding as to how to apply it to a corporate body. So the only challenge that remains with them is to understand how a corporate sector or how a corporate body works. That is the constitution, what is the decision making process in it, what is the machinery which takes care of the entire working of the corporate, who are the different stakeholders, and what is the interest of each and every stakeholder. So this has to be understood. Now, how it is to be understood, I'll come on it in detail at a later stage. But this is only an introduction part that I am dealing with. So just understand that you are not saying goodbye to any of the other areas. So you did not think that if I am selecting corporate law for me, for myself, then possibly I will have to say goodbye to other areas. And if I find tomorrow that I'm not interested in this, I want to go back to that area, I will be suffering. It won't happen because you're not saying goodbye to other areas also. Okay. So that option is always open with you. Then, as far as what do you call your particular corporate law practice, we'll go to the next slide, Samir. Now here what we have to understand is that when we say corporate law practice, I divide it into, or in general, it is divided into two aspects, that is litigation and consultancy. Now, what is litigation and what is consultancy? Now, it may be at times they are used, the terms are used interchangeably, but they are actually different. Okay. Now, you may say, what is the difference? We don't see any difference. They go together. But even if they go together, they don't they are not synonymous. They may go together, but they are definitely are not synonymous. Okay. So then now when we say they are not synonymous, what is the difference? Say for instance, you are drafting a contract. Okay. You are analyzing terms and conditions of the contract. Or say you are vetting a contract and advising your client whether to enter into the contract or not. This amounts to consulting or consultancy. And suppose tomorrow, after giving advice and everything, he goes and signs a contract and he enters into a contract, and the other party resorts to some misfeasance, and something goes wrong. And say, for instance, there is a breach, he comes back to you. Now you resort to litigation. That is, you are approaching an adjudicating authority or a court wherein this particular contract either has to be enforced or damages have to be claimed. So this is the difference between litigation and consulting. Consulting takes place when there is no dispute. It is only an advice. It is a guidance that you are providing, an advisory way of doing things. And when you say litigation, in litigation, there is a presumption that there is already a dispute, there is already a breach there, and this is redressal. That is some kind of remedial measure that you have to work upon. That this is the area when you say that a remedial measure has to be taken care of, then only you will get to know that this is the area of litigation and not consultation. Okay, so this is the difference between litigation and consultancy. Now you will say, what is the pros or cons, or why should I do this? See, there are different ways of looking at things. Why you should go for consulting, or why you should go for litigation. Most of the times they go together. As I told you, the client who comes to you for advice will definitely come back to you when there is a question of litigation. He will definitely come back to you for advice. So most of the times, both of the things exist together. But there may be times wherein you don't take interest in consultancy and you concentrate only on litigation. Now, in my personal view, I would say that it is better that both the things are followed together for two reasons. Very first thing is that the client remains with you, be it for consultation or be it for litigation, he remains with you. Again, you get complete control over it. If somebody else has been handling consulting and he has advised in a different way, in a wrong way, and the client comes back to you, you cannot make certain corrections which otherwise you would have done in the beginning. Okay, so this is the reason that you should concentrate on both the areas. Yes, so that is regarding what is your consultancy and litigation. And going further into it, as I told you, in litigation, there is a prerequisite or a presumption that there is a dispute, there is a breach, and what you are doing is getting some kind of redressal or some kind of remedy to the person who is affected. Now it can be on either side. You may be who is affected person, who is the person who has grievances. That's a different story. Now you can be on either side or that side, depending upon which side you are. Okay. So, but what you have to understand is there is no when you say again talking about litigation, though is something, or even consultancy is something which deals with a corporate body. So you have to be specific and clear about the workings of the corporate body you are dealing with. Now, I'm using the word corporate body because when you say corporate law practice, it includes Indian companies, and not only Indian companies, even foreign bodies who have subsidiaries or parent companies or holding companies or associate companies in India. There can be different ways in which a particular entity or business entity may be working. So that is why I'm using the word corporate body and not restricting myself to Indian companies alone, because corporate body is a word which has a larger import as compared to the word only company. Okay. Now, coming to consultancy, as we have seen, uh, that is, it is something wherein you are giving advice. This particular client has come to you for getting some kind of advice where he needs guidance. So you are supposed to tell them what are the options available to him and tell him what are the pros and cons of each and every option depending upon what decision it is. So I am talking in terms of strategic decisions, and tell him the pros and cons of it, and after explaining, help him in deciding upon one particular option. Okay, this is what is meant by consultancy. And consultancy in that is mainly deals with compliance aspects also. Now, when you say compliance, now compliance can be under the Companies Act, it can be under SEBI, it can be under RBI, it can be under anything, FEMA, anything, depending upon what is that particular business entity into, what is the nature of its business. If it has any particular specific regulator, say for instance IRDA, that is insurance company, then you have to see that as well. Now, when we say consultancy, invariably it means compliance aspect. Now, what do you mean by compliance aspect? Now, when you say compliance, it means that there are certain prescribed or rules or regulations which need to be complied with for the entity, so far as this particular regulator is concerned. Now, when these regulations have to be complied with, and if they are not complied with, the regulators take an action against an entity. This is not like a contract wherein both the parties are private parties. This is a case wherein regulator is taking an action. So whenever you say that it is compliance, compliance also can, if compliance is not taken care of properly, that can also lead to litigation. But here, one side will be yours, that is your client, and the other side will be the regulator, who asks for explanations, who sends show cause notices, which need to be explained and addressed, and all these things will come over there. Depending upon who is the regulator, the process may vary. Okay, so when we come to this, we will say what is the difference between the what do you call compliance and what is litigation. Now, I will give you a simple example over here. Say, for instance, you are on the road and you want to cross the road, but there's a red light. The signal is red and you are not able to cross it. You have to stop before the red light. Now, possibly you want to cross the road because it's an urgent matter for which you want to cross it. It is urgent, so you cannot wait. There are two ways. Say, for instance, you break the what you call signal and cross the road, and there's a policeman standing over there who catches you. He may issue a challan to you. Now, this is what is litigation is all about. Okay, this is where the litigation begins. Similarly, we will take another example wherein you are standing on the road and you want to cross, and you can see the person who can catch you over there. So you don't want to go there, but instead there is a petrol pump, and you realize that your petrol tank is getting empty. So you go to the petrol pump, you take a diversion, and from the diversion you that is you fill up your tank, and then you from that is for your vehicle's tank, and from there you go and join the other side of the road. Here also you have crossed the road, but without any complications, without hazards. Now, you could be either, if your client is standing on the road, the client can straight away cross and get caught. That will lead to litigation. And if you're a good consultant, you will tell him that, see, there is an opportunity as it is. You have to spend some time on filling up the petrol tank. Why don't you go and fill it up and then join? This is not this is not avoiding law, or this is not what you call crossing the legal barriers or framework. No, this is a way of resolving things. So here you are doing your work, you are getting your tank also filled in, and then you are crossing the signal as well, and you are not, nobody catches you because you are well within the limits of the that is limits or framework provided by law, and you are able to reach the place wherever you wanted to reach in time as well. So this is the difference between how to give an advice, what is a litigation, what litigation will be aspect will be, and what consultancy aspect will be. So this difference has to be understood. And you will see that in most of the cases, both these aspects coexist. It only happens that we at times don't look at it properly, or the client fails to look at it because the client doesn't know. Obviously, that's why he's coming to you. Okay, so he takes a wrong step and then comes back to you to get the proper advice. Okay, so this is the difference between your consultancy and litigation. Okay, now the other thing is that so far as your employment prospects and opportunities are concerned, we have understood right now what is corporate law practice to a certain extent. Though it's not an exhaustive list, I'm only giving a general idea. But then what are the opportunities available for a law graduate once he does completes his law graduation? Yeah, this is slide 8. Yeah, this we had, yes. So now where do these corporate lawyers work? What are they doing? Now, it can be a law firm. So they are engaged in drafting agreements for mergers, acquisition, joint ventures, labor or corporate law related matters. Now, these can be what you call areas which they deal with. And typically in corporate firms, or sorry, law firms, what happens is that the number of clients is more, the work, that is the variety of work, is very large, and it covers both consultancy as well as litigation practice. Now, why consultancy? Because there are many what you call corporate clients with the law firms which need compliance from time to time, and that is why they take care of the compliance work as well. And if there are any litigations involved, if there are any disputes which are emerging, then the disputes are also taken care of by the law firms. And that is why when you say that the exposure in the law firms is very good, is the best, this is the reason why it is so, because you have exposure in both these areas. And that too, since the clients come from different walks of life, different kinds of companies which are in different industries, the exposure that you are given can be of various types, of various industries, and the different enactments and the different regulations, different kinds of experiences, different nature of what you call litigations. Some may have even criminal aspects, some may have civil aspects, some may have regulatory aspects to handle. So the variety is very large, and that's why when somebody says that working in a law firm is the most advantageous position, this is the reason why it is more advantageous, because of the exposure that you get. But it may so happen that even if you join a law firm, you are not getting sufficient exposure. It can happen because you are not getting proper your profile, the kind of work that you are getting is not proper, or the exposure is not enough. Then again, even if you are in a very big law firm, if you are not getting, your profile is not good enough, your job is not good enough, then you may not get the exposure. So you always have to think in terms of exposure. So the next one is in-house counsel. Now, in-house counsel consists or deals with a team of people who work for a particular management for one particular company or group of companies which have a common law department or legal department. That is some kind of law support, legal support. Now, these people deal with the requirements of that the employers, whoever the employer is, whether the company or whether the group, the entire group, whichever way it is. The requirements of the management over there in this particular setup, and the day-to-day requirements of that, because big corporate houses, as you know, have all kinds of work to be taken care of, right from drafting to vetting to contracts to filing what you call for IPR, they say maybe a trademark or a copyright or a patent, or there may be litigations, there may be management disputes going on, so you have to go to NCLT also. So that can also happen. So the thing is that they are backup support, legal support in an organization which consistently keeps on addressing the requirements of that particular management to which it is reporting. Okay, and that is why it is called in-house, because these people are employees, or some kind of arrangement will be there wherein these people report to the management of one particular that is one particular management or management of one particular group. Okay, Then the next one is your solo litigation and consultancy. Now, what is solo litigation consultancy? So, as the name suggests, it's a very clear case wherein you are the person who is running your law firm. You are the person who lead it. Even if it is small in size, you are the person who is the whole and soul for the organization or the firm. And the advantage here is that you don't have to report to any other senior, wherein you take permissions for changing courses or taking up cases and things like that. For everything, you are the person who is a decision maker. You will decide upon which area to concentrate on. You will decide which client to take and which client not to take. So the choice is entirely yours. So this is the advantage. But there is a rider on this, and the problem is that when you say you have a independent practice, when you say you have a choice, there is also risk involved in it. So the risk is entirely yours, and accountability and responsibility also comes down upon you. So you have to be very careful while selecting clients and while taking cases. And even if you take cases, you have to do your homework on your own. There is no team to support you, or if it's because in the beginning it's not good, there is not, it is not going to be there. The team is not going to be there, and even if they are there, they will not be of much use. So all kind of what you call analysis, research, or whatever you want to do, you have to do on your own. Whatever what you call precedents you want to see, whatever judgments you want to see, whatever enactments you want to check, everything has to be done by you. So you are the whole and soul. So but the advantage is that because your exposure is more, because you are the person who is in charge and you are taking more risk, the advantage is that you end up learning more. You know how to handle pressure. You know how to handle each and every client, because you are interacting personally with the client, and you know and all the aspects of the client, that which may not be there in the other two cases, wherein somebody else in the team is handling some other aspects and you are handling some other aspects. The areas may not coincide at all. But here, when you are the whole and soul of the person, then you know that what this person, if I take this decision or advise this particular decision to be taken, what you call to this person, to this particular client, what will happen? What are the implications on the other aspects? Say, for instance, if I give an advice that you get your company listed, then can there be other repercussions? Does the company have FDI? Is that permissible? What is the area? What is the track record? Now, you may not be aware of it if you are in a team, in a big team. But if you are the only person who is advising them and things are under your control, or you have your own subordinates, you have complete control to understand, you know, all the aspects of the client. So this is the advantage. But it requires some kind of risk taking and adventurous nature. So that goes without saying. You have to be bold enough. You want to start on your own. There's nothing wrong in starting on your own, but you have to be bold enough. And you should not get depressed by small setbacks. Setbacks are not failures. Okay. So this is regarding where you can, what are the opportunities available to you. So we are just, I'm just reading through this list again. Is not an exhaustive one. It's only an inclusive one. So I'm just covering few of them. Now, corporate restructuring. When you say corporate restructuring, we are dealing with or talking about mergers or amalgamations, or say buyback of capital, buyback of shares, or it can be some other kind of arrangements wherein there is a takeover or an acquisition, any kind of change in the management or capital structure. Now that will come under your corporate restructuring. Now there can be many ways of doing it. Then insolvency and bankruptcy. Now, when you say insolvency and bankruptcy, it covers right from issuing notices to voluntary winding up. Everything will get covered. Say, for instance, somebody has defaulted in paying you, so that person becomes your debtor, or somebody has filed a petition against you for not payment, so handling that. So that is also covered under insolvency and bankruptcy. Arbitration and mediation is an alternative way of resolving disputes. Arbitration involves wherein there is an arbitration clause in the agreement, wherein depending upon what is the clause says, how many arbitrators will be there, it will decide upon whether you can act as an arbitrator or not. And then again, it requires certain specifications, whether you are eligible to do that or not. It requires some experience. Or mediation. Now, mediation is something that you are bargaining on one side, or you are negotiating between two disputing parties who have entirely opposite interests, and you are trying to see whether there is a common ground for meeting for these two what you call otherwise opposite parties. Then financing decisions. Now, financing decisions can include any way of financing. It can be whether by way of borrowings, it can be by way of capital raising, ownership capital or borrowed capital, or issuing debentures, or using or raising any of the securities by which you can raise funds from overseas. It is a very big area, very large area when financing is concerned. So, it deals right from IPO, FPO to American depositories to international depositories, or whatever you say, it will get covered over it, because all are financing. So you have to see that, you have to analyze what are the pros and cons of each and every what do you call instrument, or to take an ECB or to take a loan, whether I should take it from the international market or from Indian market, and if I from wherever I am taking, what are the pros and cons, and you have to take into consideration the situation or the circumstances into which their client company is. So this is regarding your financing decisions. And corporate law compliance. Corporate law compliance, again, whether SEBI has some reporting has to be made to SEBI if it's a listed company, or ROC reportings, or reportings under FEMA to RBI. It can be anything. Now, corporate law compliance doesn't involve only Companies Act also. Corporate law is a very wide area which covers many aspects. It can be Companies Act to start with. It can be Consumer Protection Act. It can be employment laws. It can be Factories Act or labor laws, or it can be SEBI guidelines, or it can be anything, FEMA or whatever it is, depending upon who the client is, or which company it is. Corporate litigation. Corporate litigation in general is a litigation in which one of the parties is a company. This is how I define it. It doesn't mean essentially that within the, or if you say, somebody may say that, see, whether if there is a dispute within the company, if there is a management dispute, then only it is a corporate litigation. No, that's not the thing. Corporate litigation means a litigation wherein one of the parties is a company. Then it is a corporate litigation. Why? Because one corporate is involved over it. So you can easily say that this is how you have to define corporate litigation. So, and again, intellectual property rights. Now, intellectual property rights involves trademarks or patents, or your designs, or say copyrights. It can be anything. That is also a very wide area. Now, this starts right from making an application to if there is a passing off, if there is any disputes there, if there are any agreements and some agreements have been breached. All these things will get covered in intellectual property rights. It's again a very big ocean. Okay. Then management and administration decisions. Now this is again strategic decisions, which has got repeated again in the strategic decision support. Now, management and administration decisions is regarding a company works through two governing bodies. First one is the board of directors. The next one is the members. So you have to understand what decisions will go to the board, and what decisions have to invariably have the blessings of the members or the shareholders. Now, how to navigate through this, what are the decisions and how they have to be taken, all these things will come under your management and administration decisions. Okay. Then business law governance is a general governance regarding all the enactments, everything which is required to be complied with so far as business is concerned. It can be contract act, it can be a sale of goods, it can be transfer of property, it can be any commercial contracts that you are entering into, it can be dealing with compliance aspect of the company, it can be anything. That's also a very large area. Commercial transactions and contract analysis. So contract is everywhere. Basically, contract is the basis of any law. If you ask me, any enactment, contract is the base. So commercial transaction contract analysis is something that which will involve both consultancy and litigation. In all these areas which have been mentioned here have their own consultancy areas as well as litigation areas. So all these give exposure in both the areas. It's not reserved for one area alone, so everything will get covered here. And then again, strategic decision support. What kind of decision? This will involve more of consultancy, I suppose, because you are going to advise the promoter group or the board regarding what decision is to be taken and why it is to be taken, giving them the information on which they can decide upon which particular uh, area they should treat upon, and what is the option that they go for. Then Fema compliance, as I told you, what is Fema compliance? See, the thing is that if your client does not have any transactions which involve foreign exchange, then there's no Fema compliance. But if there is some kind of what you call FDI involvement or some kind of foreign exchange, some transaction wherein foreign exchange is involved, then you have to check whether Fema will come over here. Now, how this is to be done, I will again tell you at a later stage how to differentiate that. So this is the general understanding that what are the areas which can get covered under corporate law practice. Okay. So from here, the next slide is regarding is the law degree certificate. It is sufficient. There's no doubt about that. But yes, if you do, apart from law, if you do CA or CS, it can have certain edges. You can have a certain edge, or you can have a certain advantages which other people may not have. It's not necessarily they will not have, they may not have. But again, it will boil down to what kind of an individual here. So we will discuss this in detail. Depending upon, you have to first understand that when you're completing your law, you're already a professional, and respect your profession for that. Okay, so don't look down upon your degree, and don't think that I have done only law, and if I have not done anything else apart from this, I won't be able to succeed. That's not the case. Now, what it involves when you say you are doing CA, or what it involves if you are doing CS, we'll discuss in detail so that you can understand the difference and weigh the pros and cons, and then take a decision. Okay. See, when you do law, you already have a professional degree with you. It's not that you are a novice, you don't know anything. But as I told you in the beginning itself, when we do our law, we have an idea or a general idea about all the enactments or the legal system in the country. Okay, but we don't know what happens, or we don't have any what do you call, exposure of in-depth analysis of any of the particular subjects. Now, it can be anything. It can be Companies Act. It can be anything. We don't have the entire in-depth knowledge of the subject. That is the problem. Now, when you compare yourself with a person who has done law and also CA or CS, the thing is that they have a typical structured learning structure in their syllabus, in the course, which allows them to learn the subjects in a particular way. Now, when you do law, there also you are learning in a very particular structured manner. So whenever some client walks into your office, you know that what is it required of you. Though you may know what is the intensity of it, what will be required, how many hours you will have to spend on it, but you will get to know, okay, this person is talking about property. So I have to see whether there's a contract, whether I have to see whether transfer of property is involved. So you know what is to be seen. Now, similarly, when you talk about Companies Act, now why do we say that in other areas we don't talk about C or CS? But when we come to corporate law, we say that C or CS is important. Why is it? Because the reason is that to understand how a company works, you have to a detailed understanding of the constitution of the company. That is, you have to understand what is that corporate body doing, why it is in existence, how does it work. As I told you, there are two governing bodies. Which particular body has what rights? And what happens if one of the things are breached? So when all these things are there, you have to understand and you have to learn in a proper way. When you do CA or CS, right from the beginning, it is considered the syllabus is such, what do you call, it has been planned or designed in such a way that even a person who is a layman, if he learns things stage by stage, he will be able to understand in a better way. So this is the difference between a person who has done his CA or CS and the person who has not done it, but has a law degree. But there are certain aspects wherein you have to see and understand that the syllabus for these exams don't have corporate laws alone. There are many other subjects as well. So when you want to do or you decide upon doing it, just go into their sites and see what are the other subjects which are there, which need to be studied to clear the exam, in order to clear the exam. And when this comes up, it may so happen that you are not interested in some of the subjects, or you may not find any inclination for those subjects. But yes, you have inclination for corporate law, but you don't want to do any of the things, and you don't think that it is your calling. After reading the entire thing, you feel that, no, this is not something which suits me as a person. My nature is not something which I can do this. See, it's not question of good or bad. Now I may be handling corporate law cases. If somebody says or gives me, see, you have to what do you call, defend a person who has been convicted, or who is accused of killing somebody, murdering, I may not take it up. It's not that the area is good or bad. The decision rests with me whether I have a personality, I have a nature to address that particular issue. This is the only stopping point for you. So you have to see whether it suits you. If you think that, okay, the subjects others, there may be accounting, there may be financial management, there may be costing, there may be other subjects also, auditing, all these things will be there. You have to see what it involves, whether it will be interesting for me. If you find that they are interesting, okay, go ahead, join the course and complete it. All the best. But if you don't have that interest, it is okay. Even if you get registered and you feel that I'm not able to clear, don't get depressed in between thinking that, okay, I'm worthless because I'm not able to complete it. See, people have different mindsets. People have their own set of talents and skills in them. We have to realize and understand what our skill set is. This is what makes you a successful professional. What will happen if you don't clear CS or CF? What will happen if you don't do it? Do you think you'll be a failure? No. If you learn things properly, right from grassroots, you won't fail. Okay, at certain points of time, if you may find that you're not able to understand the commercial aspects of a transaction. I don't know why this particular contract actually failed. I don't know how to redress this, or why this company, there are different stakeholders, they are fighting for a different thing. I don't know what is the problem exactly which is happening over here. If this is the case, or there are some other IT requirements, that is income tax requirements, which you are not able to address or able to understand, you may have to rope in some other profession who will help you, and they do provide help. And then that, this is also not a very big drawback. In fact, lawyers do well when they have good rapport with other rapport and networking with other professionals. They do well. It's not that why, because they have these people, the other practicing professions like auditor or a CS. They have what do you call, a constant or a set of clients which are companies. And what happens is that every now and then some legal aspect is going to crop up there. And if at all there is something is cropping up, and if they are not able to handle, they are going to come to you. So it's a win-win situation. But what happens is that if you have your own skill set, if you are yourself qualified, you will have a better understanding of the case. That is yourself, you will be able to understand and interpret what is happening in the company, what is happening with the client. So this is the only advantage. And the learning aspect, again, we will come to that also. I will cover that also. So don't think that if you have not registered, or you're not able to do, or you have registered and you're not able to clear, everything is lost. Don't think like that. It is not the case. Every profession has its plus and minuses, and you are in a very, very respectable and very good profession, where most of the professions stop giving what you call earnings by 50 or 60. That is a time which is the golden age for you, when you start earning, and you start earning like anything if you work on it. Okay, so this is what you have to understand, whether if I need to do CA or CS, is it that the profession itself is attractive to me, or if I'm going for, or is it that I'm going there for some particular reason? If I'm going to there for some particular reason, what is that reason? And is this particular course or clearing the examination going to help me? If it is going to help me, to what extent? Yes, but there's a distinct advantage if you are doing CA or CS. The advantage is that you have multiple qualifications. Then again, you can practice only one profession. So you cannot say that I am a CA, I am a CS advocate. One fine morning, you are in the morning you are advocate, in the evening you are CS, in the next day morning you are a CA. That is also not going to work over there. So you have to choose one profession. Anyhow, you have to choose one profession even then. Okay. So only thing is that the knowledge ground or the skill set will always remain with you, and it is advantageous in the competitive world. You will see that many people will say that it is advantageous. The reason, there is reason for that. And what is the reason? That is because of the fact check that people do. The fact check, when you see the thing that is there prevalent in the market in today's times, is that when you say a law degree holder, there are many law degree holders. If you say when I am a CA, there are many CAs. If I say there is a CS, there are many CAs. The reason is that how do you stand, you try to, how do you stand out in the crowd? The more qualifications you have, the more degrees you have, it is definitely going to add to your profile. Okay. And in practice, what happens is that in today's world, the client or the corporate company or the promoter, whoever is coming to you, is busy with his business. He is so busy with the competition because of the tough time that his competitors are giving. He doesn't have time to go to an auditor to a separate office, and going to an advocate in a separate office, and consulting a CS in a separate office. He always thinks that if I am getting all the services under one roof, that is the best possible thing I can have. And this is where bigger firms, larger firms, stand to gain, because they have more skills and talents in under one roof, wherein all the requirements of the client gets addressed instead of having separate small compartments. Okay. So this is the reason why even law firms have company secretaries or chartered accountants or different professions in employment apart from law graduates. This is the basic reason. Because for a client, the understanding is that if the client comes, walks into your office, understand that he thinks that he, all his problems, all his legal or whatever compliance is required, will get addressed. He doesn't have time to knock doors and enter each and everybody's office saying what is the kind of work that you can do, what is the kind of work you can, the other ABC can do. So he wants all the services under one roof. But this can also be surmounted. How? If you have a team or you have a good networking with other professionals, this particular problem can also be addressed. Now, how to do it, that is up to you. What is comfortable for you, what is not, is again up to you. If you want to study all of them and you think that you have sufficient time and you'll be able to do it, you'll be able to concentrate, well and good. That's the best thing to do. But don't get depressed if you are not able to do it. That's not the end of the world. Okay. Then again, when you say that you want to do CA or CS, understand one thing, that there is no attendance required. There is no regular attending college or anything is required. There is no age limit. So you can, whenever you get time, you can study and you can prepare and you can write the exams. And if you're doing law, you may get exemptions also. So all these things have to be considered, and do take an informed decision. Okay. Then we are coming to why it's that. Yes, I had just touched upon this aspect. Why do we think that the CA or CS people have a better knowledge of the work that we are doing? Why this happens? Okay. The thing is that, yeah, Samir, I will request you to go to the next slide, that is slide 11. So what you are learning, how you are learning matters. Okay. Understand that the corporate body is like a tree. Okay, I'm just telling you a story so that it becomes easier for you to understand, because some of you may otherwise be able to understand, or some of you may not be able to understand if I explain in technical terms. It is like a tree, a big mango tree, which has fruits, which has leaves, which has different branches, and a very big large trunk and roots, which you don't see, which is underneath, that is below the ground. Now you have a balcony, some houses there, that is just next to the mango tree. Now there are fruits over there, so there are certain mangoes which are in your reach. You can touch and pluck them from the balcony. Now, for instance, if you see that you are handling only a listed company, Okay, there is only a client which is coming to you, and that company is a listed company. Okay, you are seeing only the SEBI aspects of it, and you are studying that SEBI aspect, and you are saying that okay, I have studied SEBI, and so I am an expert in corporate laws. This is where you commit a mistake. You may pluck the mango called sebi. You may eat it also. It may be sweet also. There may be other mangoes also over there in that branch, but that is not the only branch. Why? Because while seeing that branch, you're missing out on the tree. You are missing out on the all the other branches. So what I am trying to explain here is that if you want to learn company law, now why learning company law is so important? Because your client is a company. Okay, don't think about other things right now. If a person is coming to you, you can see a person. If it is an individual, you will see a person, entire person. You can see his eyes, nose, everything. Okay, fine. One person is standing in front of me. In a company, you don't see all the aspects because it is an abstract body, artificial person. So, in order to understand what kind of a company or what kind of a culture this particular corporate body follows, to understand what are the interests of the different people who are the stakeholders in the company, you have to understand the concept. So, if you want to understand Companies Act, start from the basic level. Some kind of book, your 11th standard book or 12th standard book, or even any of the CSCET or any small book which gives a general idea of company. Start from there. Don't start from the Bare Act. It is not like other enactments. Now, your Partnership Act or Sale of Goods Act, which are now everything has come under GST. So, don't think that you have to see only one aspect. No, you have to understand right from the grassroots level how the company comes into existence, why it has come to existence, and what is its purpose, and try to understand a company from a very smaller sector, that is say a private limited company which is closely held company, and then that company grows in tomorrow into a public limited company, and then it goes into a listed company, and then becomes a multinational. Okay, so when it grows, if you study it in a proper way, there is no competition, no professional, no other profession, nobody is going to give you a competition. Okay, why? Because you have studied the subject in a proper way, and by the that is by and by, when the next phase comes in, that is you are say you're crossing upon, first as a sole proprietor, then it becomes a proper private sorry uh, partnership, and then it becomes a private limited company, and it grows on, and then it becomes listed. If it becomes listed, SEBI compliance is coming. If it is a private limited company, right from day one, there are compliances meant for a private limited company under the Companies Act. If it's a public limited company, the exemptions that which are available for the private limited company will go, and whatever is there for public limited company will take place. Okay, replace them, and then you have to see when it is getting listed. Okay, SEBI compliances have to be taken care of. If FDI is coming in or some foreign transactions are happening in the company, then I have to see whether FEMA is compliant. And if I have some intellectual property in the company, I have to see what it is. What is a property? Is it some kind of mark which has a distinct standing in the market? Then it will be a trademark. Is it something, what do you call, some software program which has been designed or which has been written by any of your client, what do you call, team members, or say some artistic work or design has been done? Whether a copyright will be registerable for that? Is that required to be done? If there is an innovation, whether patent has to be filed? So these are the different branches. If you start studying things in a proper way, then you will understand the whole picture. Instead of that, if you are going to try to pick only one particular fruit, okay, you will have that fruit, but what about the rest of it? So first you have to understand there is a big tree. You have to study, you have to understand right from the root level, and grow what you call upwards, and see what are the other branches which are available in the tree, so that you can understand how many there is fruits, that is how many mangoes are on this branch, how many mangoes are on that branch. And nobody can stop you from tasting all the or plucking all the mangoes also. So that is also there. Even if you are not able to do it alone, you will need some support system, you will need some more team members for it, but you will be able to do it. So this is how you have to learn things. So don't think that because I have seen people who struggle to understand what is the difference between a transfer of shares and what is the difference between transfer of shares and issue of shares. That should not be the case with you. You have to understand what is transfer, what is issuing. What is issuing? Issuing is the company is issuing shares to somebody, some shareholder. It can be a rights issue or a preferential issue or whatever it is, bonus issue, sweat issue, it can be anything. Now, how do you understand if I say so? In issue itself, there are so many varieties. Now, if I tell you all the varieties together, you won't be able to understand. But if you see what is issue, it is inviting some kind of, in some way, it can be any modus operandi, can be anything, procedure can be anything. Procedural aspects you leave apart. I am taking money from somebody. Now, what kind of money? Ownership money. Or I am even, that is for some reason, I am bestowing the privilege on somebody that the person can become a member of the company even without paying anything. Now, why I am in consideration of what? This I have to see. Now, how can this be equated with transfer of shares? Transfer of shares is a case wherein there is already a shareholder. He is transferring his interest for money to somebody, a third party. Now, that third party is again transacting only with the shareholder. There is no company in the scene at all. Okay, the company comes into scene only when they intimate the company that there is a transfer. Otherwise, not. So there is a difference. There is a way of learning things. If you learn it in a proper way, there is no disadvantage you are going to have as compared to a company secretary. Now, company secretaries also have their own disadvantages. The company secretary cannot appear in a court of law. Why? Because he's not a bar council member. He cannot become a bar council member. So every profession has its own pros and cons. So you have to understand what is the pros and cons, and then what is it that suits your nature, your personality, and then take the decision. Okay, so how you learn, what you learn, from where you learn matters a lot. Just because somebody told you that, and don't join the bandwagon effect when somebody says that you read this book and everything will be done. Had that been the case, everyone would have become a successful corporate lawyer. No, everybody's story differs. No one person's story will be similar to someone else's story. Everybody's story is going to be different, and that is what makes them different. So your skill set may be entirely different from ABC who gives you advice. Now ABC's skill set may be entirely different. Something which worked for him may not work for you, and something which he did not work for him may work for you. It can happen. So that's why keep your mind open and let ideas flow in. But don't get confused. Understand what is it that you want. Now, doesn't when you are inviting ideas doesn't mean that today you are getting registered for CS, tomorrow you are getting registered for CA, then you decide upon doing nothing. Don't do that. That is why I am telling you, go and find out what is there in the syllabus. Is it something which interests you? Do you know sufficiently about the subject? Try to understand what the subject involves. What does it cover? What it deals with? And then decide whether this will be an interesting area for you or not. Even if you say that you are going to be in corporate sector alone, even in this particular sector itself, it's a very big sector. There are a lot of opportunities. Now, hundreds and thousands of people, even if there are so many corporate lawyers, even then you will have work. That is the area, and that is an evolving world. It is a emerging sector, which is growing, which is only in infancy stage, right? As of now, this stage that you are seeing is in infancy. It's going to go further. So don't be and that is don't go by what someone else says. Do your homework. Do find out on your side what is it that suits you. But whenever you study, whenever you learn it in a proper structured way. Clear? Yes. So now coming to our, oh my God, we are already on 6. So we'll try to complete. Do I have time, Sami? Sufficient time?
Yes, ma'am. We are running a little bit late, but as soon as possible, we should be able to wrap it up because we have to address questions as well. It should not drag on too long.
Yeah. Okay. So next we are coming to your personal traits which you have to work upon. Okay. So the first one is I would say that it's patience and hard work. And why patience and hard work is required. So we are coming to the 13th. Yes. Now why patience and hard work is required. See, unless and until you are patient with your client, your regulators, your colleagues, your team members, yourself, your family, you won't be able to achieve it. That goes without saying. The day someone says that, someone gives you a compliment that you have become very patient, just realize that you're on the right track. That is the first compliment that comes to a profession. Now, why is patience required? Now, patience is required with the regulators, with the adjudicating authorities, but they are not going to, you see a straight case, you want the order next day, they won't give you the next day. They will take 10 hearings, 10 what do you call adjournments, and then only the order will come to you. So you need to have.
Sorry. Excuse me, Mr. Abhay Shukla, can you please mute? Yeah. Sorry, ma'am. Please continue.
No, that's fine. So that's why patience is a very, very important aspect that you need to have and work upon. And you have to be patient with not only with your regulators or your adjudicating authorities or your colleagues, with yourself also. In the beginning, you may realize that you have committed some mistakes. It is okay to commit mistakes. It is okay to commit errors. It is okay, as long as they are not blunders. And with your whatever you have learned till now after completing your law, I believe that you cannot commit blunders. It's difficult to commit blunders for a person who is so qualified. Okay, so when you say that you should avoid, when I say that you should avoid committing blunders, just see to it that it is not something which cannot ever be corrected at all. And if even if you are committing small mistakes, it is okay, you correct it in your next attempt. Next time when you are handling similar case or petition or consulting or whatever you are doing, see to it that you don't commit the same mistake again. So be patient with yourself also. That is the main thing which is required. Just tell yourself that you are going to learn it eventually, though it is going to take time, but you are going to learn. That is what the intention is. Okay, and hard work. Now, if you may argue that smart work is better than hard work, for smart work also hard work is required, because unless and until you work hard, you don't know what is smart work is. Now, smart work may be doing things at a faster pace, but unless and until you practice on it, you work on it, and you work really hard before, how do you know that this is what is to be avoided, this is what is to be done, this is what is to be taken into priority? If that doesn't happen, how will that amount to smart work at all? You will never reach a stage wherein you are doing smart work at all. So patience and hard work are they are inseparable, and they have to be there. Then teaching and public speaking. Yes, this I want to concentrate on. So this is something that I would like to concentrate now, focus on. The reason is that because many a times it happens that we suffer in our communication skills because we don't know what the other person is thinking. Now, when you are communicating, be it with your client, be it with your colleagues, or be it with your adjudicating authorities, you are standing in front of a judge in the court. Now, the thing is that if you feel that someone questions you or argues with you, it essentially necessarily doesn't mean that this person is looking down upon you. This is the first thing that you have to remove from your mind. If somebody is asking you questions, he is taking help from you, it only means that he thinks that you are in a position, you are better informed, or your knowledge level is such that you can help him out. Or possibly you know something which the other person doesn't know. So it doesn't mean that it is coming as a threat. So if you do some public speaking and some teaching in some way, it always helps in understanding that there can be different perspectives to the same thing. Now the thing may be the same. The fact that is what you are noticing, what I am noticing, or ABC and PQ are noticing will be the same thing. But the way they grasp it, the way they understand it may be different. And unless and until we understand there can be different perspectives and we are open to it, we'll never get the complete picture. This is where your teaching and public speaking comes in. When you are doing public speaking or teaching, different students or different people from the audience are going to ask you, put different questions to you, which will make you realize that okay, there is also a different way of looking at it, I never knew. And the thing is that Since I have been in teaching, I can tell you that the more you teach, you end up learning more. I don't know about the students whether they learn it or not. That's a different story. They may learn it. That's a different story. There is a purpose of it. That's why I'm still in the field. Otherwise, I would have gone out. The thing is that I end up learning more. Why? Because you explain the certain concepts and things again and again, you end up learning things more. Now, it may so happen that all of you may not get an opportunity for public speaking on a very big platform and things all that. Don't worry about that. Start with the kids which are the kids which you come across in your block. Take classes for them. There's nothing wrong with that. What will happen? The benefit is that they will come out with different ideas. You will learn different things from them, and you always keep on learning all through your life. There's no end to learning at all. Okay. Now, what happens is that suppose if their parents are into business or somebody in the family into business, business may also come to you. So it is nothing but networking. So you can take it that way also. But then public speaking and teaching helps you in expressing your ideas in a better way and accepting differences in ideas and understanding different perspectives without getting threatened. Now, all these things contribute to your confidence, which helps when you are in your if you are arguing in a court of law, or even adjudicating authorities, any of the regulators. It goes a very long way, because the regulator may be looking at things in a different way. You may be looking at things in a different way, and when you try to convince the person, this is the way that I am looking at things, then the other side will try to understand what is the area that you are touching, which was unseen for that person. So this is where teaching and public speaking comes in. It's very important, because it is it is bread and butter for you. Your livelihood depends upon communication, because you are in a field wherein interactions are required. So you cannot do without it at all. And the next one that is there is regarding
Ma'am,
your,
sorry to
yeah.
interject. I think we're running a little late. So if we could move forward to the questions at this point, if you do not mind.
Yes, okay,
Yeah.
fine.
I'm really sorry to cut you short, but
No, I
we
can
have only
understand that.
booked the Zoom for an hour, so we'll have to
Okay,
speed things up a little bit. I'm very sorry.
okay.
Okay, so we'll move on to the Q&A section, and I think some of the questions as such will also deal with the last slide. So firstly, we have Karthik asking that his final goal is to become a professor in a college, and he needs for that an expertise in corporate and financial law. But to begin with, he would need some field expertise. And which type of corporate job would you suggest that he would gain a knowledge at the initial stage, which would then help him become a professor at his later life?
See, when you say academics, and when you want to become a professor, your academics has to be strong. So the conceptual knowledge has to be strong. So it's better that you work upon your conceptual knowledge in academics, so that your profile can have, that is, you can add weight to your profile by saying that either you have done your LLM or some kind of PG, LLM or some kind of PhD, or even if you are saying doing CS, that may also help. But then the difference is that you have to see that the kind of area that you are going into. If you say that you want to enter the corporate subjects, then again you have to specialize in those subjects which you want to do. That is, say, if you are comfortable with doing, say, any of the commercial laws, you can specialize in them. If it deals with Companies Act or corporate laws, you can specialize in them. Either you can do any of the university specializations or that is offered by the universities, or you can go for professional courses also. Now that definitely will be helpful to you in understanding the subject matter.
I guess a follow-up question would be, and I feel that most people do have this doubt as to how important doing an LLM is after your BA LLB or your BCom LLB or whatever that you do, or your bachelor's in law first. How important is a master's degree in becoming a successful and established corporate lawyer?
See, it is of academic value. Okay, it has academic value. If you are going into teaching seriously, then academics matter a lot. LLM will definitely help you. Okay, but if you are going to enter the area of practice, Then personal traits, that is your personality traits, which somehow we had to leave in between, will help you more. Because if you have, even if you are a gold medalist, and even if you have multiple qualifications, but if you lack in interpersonal skills, you are not able to express your ideas well, and you are not able to gauge what the other person is thinking, then in that case, even if your academics is very good, you may not succeed as a corporate lawyer. The reason is that the client who walks into your office is interested in your profile only to understand whether you will be able to address his problems. If he comes in and he is impressed by your profile, and if he comes and finds out that you are not able to help him and you are not able to address his aspects or issues, then he will not come to you for the second time. Now, the way I put it would be is that your profile or your qualifications and academics help you in attracting a what you call a client. But keeping the client requires entire different set of skills. It requires, then it comes down to your personal level. How, what kind of person you are? Are you able to that is understand what the person's problem is? Are you able to address it? All these things will come in. So no amount of awards can compensate for that, those personality traits that you have to develop. And for a practice, I would say that you can be a successful practitioner only when you work upon yourself as a person. If you are a successful person at the personal level, then only that will amount to growth in what you call your practice as well.
Okay, thank you, ma'am. Anushka also has the question which a lot of people have asked similar questions, so I'll ask it as one direct question. As you know, IPR was the booming sector a couple of years back. What, according to you, in the next 5 years, would is an up and coming area of corporate law? And
IPR
what?
still is a IPR still is a good area. If you ask me, I would say that IPR still is a very good area, and there are not many corporate lawyers in it. I don't know why it is so. Possibly it's not. That is again the bandwagon effect, that everybody, all my peers are following some particular path, so I am also following the same path. So don't do that. IPR is also a very emerging, very evolving area, and day in day out new things are coming in, and that is that you can, it can give you international recognition. That's what I would say, that no IPR person or a practitioner will be a person, because see what you are doing in IPR is seen by the not only client but his competitors. Everybody looks at you. It has a different to say it has a different aura. That's what I can say, that I can call that only that, because it's difficult to define. Because it every IPR, say for instance, you take the example of a trademark. You may forget the name of the company, but the mark will always remain. That will remain in your mind. It's not only with the client, it is also, it recognizes even the consumer's loyalty. So consumer also remembers that. So company names you may forget, what ABC Private Limited or a PQR Limited or whatever it is, but the trade, that is the marks which are associated, the brands are always remembered. So it has a very high value, the market, and it's an emerging area. It's not that 5 years back or anything. It is still an emerging area, and patents is a very good area, because now the government is also giving a lot of support for innovations. So that's why I'm saying it's an evolving area. The corporate sector is itself is evolving.
Thank you,
So
ma'am.
it's not something of the past. No.
Thank you, ma'am. Ayush Kumar also has a question. He asks, would you advise working in a startup as a legal advisor slash counselor, counsel, and working his way up while garnering experience? Would working in a startup be beneficial for someone who wants to be a budding corporate lawyer?
Yes, yes. Now you may ask why. See, okay, the practical aspect I will tell you. When you are starting your own practice, no Tata or Birla is going to come to you. The reason, they have their own advisors, and people don't give up on their existing advisors unless and until they are not satisfied with their work. If they are not satisfied with their work, then they will see who are the other alternatives. And if you are a budding lawyer, you may not get their attention at all. And it's a common belief, somehow it's a misconception or myth that people have or students have, that I can do well, or my what do you call, earnings will be better only if I have very good corporate houses as clients. That is not the case. Startups are also coming up in a very good way. Now, why is it so? See, every Tata or Birla, whoever started it, or be it Ambani, they all started as a startup only at some point of time, and they have grown, and they would have, if you see the background checking and everything, they would have grown up with their advisors. And once your client, even if it is a startup, if he has very good ideas, very good business tactics, then this person will never ever leave you. If you are giving him good advice, he will grow with you, he will give reference for you. And always believe me that the word of mouth always is the best publicity, best advertisement for a practicing professional. So you may start with him, and you may end up 10 or 20 people, his own batchmates or his own friends, you are working with them, advising not only this person with whom you started, but the entire group, the entire his friend circle. It can so happen. It can happen in this way as well. So don't underestimate the strength of a startup. Your earning depends upon the kind of work or the advice that you are giving, not on the bank balance of your client. If Tata or any of the big corporate houses also recruit, that is employ you or engage you, if your contribution is very less, you are going to pay you only that much, because their what do you call, bank balance has nothing to do with your earning. They don't pay out in that proportion. They pay out as their payout, or whatever you are earning from them will be in consideration of the services that you render. So it is a best idea, I would say. But only thing is that you should have patience. You should not think that I am not earning, I have not become a millionaire or billionaire because I am advising only a startup. No, startups also do well. The idea is good. It's a good idea, in fact.
Okay. Thank you, ma'am. Thank you for that. We have a couple more questions that we'll address.
Yeah.
First is from Nikita Naveen. Nikita Naveen says that she is a third year of a 5-year BA LLB and also simultaneously pursuing CS, but she has specific interest in IPR. So,
Hmm.
what procedure would you recommend that she follow to reach the goal that that she wishes? Would she also have to opt for a special course in corporate law?
No, she is doing CS and she has done law. I think that is sufficient. If she is going to concentrate on what do you call, corporate aspects or the corporate law, that is sufficient. She need not go for anything. And IPR is something which can be learned. For instance, I have not done any specialization in IPR. I have studied only whatever I studied in my law or CS. And in CS also, IPR is a part of it, and it is only an act, and it is more. It is something which has to, which is I don't know how to describe it. It is more on the abstract side. Not everything is in black and white the way we have in companies. There are certain things. The interpretation aspect is quite wide in that, so far as IPR is concerned. You can specialize in IPR also, but if you insist upon becoming specialist, then you can get registered as a trademark agent, or do something, or attorney, anybody, she can appear. There's no problem. Law is sufficient, in fact. Law and CS is more than enough.
We have
Yeah.
another question that I personally came up with. You mentioned that there were three areas that a legal profession could work at. He could work at a law firm, an in-house counsel, or he could work as as a litigant or a consultant. What would you suggest a good avenue for internships would be for students? As you know, internships are very important for students in their learning. what
Yes.
what specific, or what would you feel is the best area that they could apply to, whether law firms or individual practitioners, that they would be able to learn the best and take away the best from their internships?
See, basically, best way out will be the general concept of joining a law firm, a good job, law firm. But then the question is whether you are getting adequate exposure over there. If you end up at a law firm, that is fine. But then if you are not getting sufficient exposure over there, then there is no point in being there. So what I would say is that see what is the exposure area that you are getting. Now there are fresher what do you call, law graduates also, who can even associate with, say, practicing company secretaries or auditors also. There also they learn a lot because of the corporate what do you call, exposure. So this may be a what do you call, unconventional way of learning, but exposure matters. So you should go for exposure, and not the name or banner name or money packet. Don't go after money in the beginning. At least for 1 to 2 years, to have the feel of the subject, you need to give time to understand what the concept is all about. So you have to see where the exposure is best. That is depending upon where you are located. What is your location? What is the geographical location? What are the options which are available to you at that point of time? And then you select the maximum exposure which is possible for you. That would be the best thing to do.
Okay, thank you, ma'am. We have a couple more questions as well. One from Bhavya Sharma, who asks whether BBA LLB or BA LLB, is there a difference while an individual learns in the terms of corporate law? Does one have a benefit over the other, or are both essentially the same in terms of
More or
corporate
less
law?
the same. More or less the same. Now, when you say BBA, it has to do business administration. So possibly they may have certain subjects or certain chapters which may have direct implications, but it is the same because you are doing law after that. So ultimately, you are going to learn the same. You end up learning the same thing. So there's not much difference.
And Ujwal Gupta has this question that if we choose to establish as a solo litigant or a consultant, how long does it take to get established?
It depends.
It's a
Depends
very
upon your
open-ended,
network.
yeah.
Yeah, it depends upon your network. First of all, start with your networking. Have more good rapport with your own what you call college mates. Have good rapport with your other friends who are not in your college, who are not doing law, but they are into some other areas. They may end up becoming businessmen. They may end up becoming CAs or CS, or all these people do contribute to your success. So friends and friend circle, I would say, is very important. When you are if you are going to think in terms of entering practice, friends are very important. And don't have any ego clashes with anybody. That is the first thing. Don't think that he is saying something, I am saying something. For small things, don't what do you call petty things should not come in between.
And thank you, ma'am. But the last question we have is again from Ujwal Gupta, who asks if we do not do CA or CS, could we choose to do an MBA or LLM in corporate finance? Or should we hire a CA or CS where their knowledge is required?
See, depends upon your resources. Okay, now I personally don't think that doing an MBA, there is a university degree, is all that helpful. So that in so far as your practice is concerned, because your practice is an area wherein you are going to stick to the legal aspects. Okay, but yes, financing is something which is an emerging area, or which can be a good area for consultancy. Okay, so you can understand, you can learn things on your own as well. And if wherever there is an expertise required, so getting a team person or even a fresher CA who is doing his CA, who has done his CA, that will also help, because the seniors may not be willing to help you. This is the actual scenario which happens in the practical side, that you may approach a person who is well experienced, who may be in a position to help you, but he may not be interested in doing it. So you have to see what is available for you. But there is nothing wrong with having a teammate who is another profession. That I advise that it is a good idea. Actually, it's a very good idea. More and more you grow, you know that other professionals have more insights, because when you start working, there are only 24 hours in a day, and when you have already your hands are full and overflowing, you cannot explore some other areas which otherwise you would have done. So in that case, it's better that you hire somebody who knows that area. So there's a win-win situation here. Wherever you need help, they can help you, and wherever they need your help, you can help them.
Thank you, ma'am.
Yes.
We'll be taking questions for another 5 minutes. If anyone does have any more questions, please send them over on the chat box. Furthermore, I'd like to remind everyone that there is the form still available for those who have not yet filled it up for the attendance. So please fill it up. Otherwise, you will not be marked as present for this webinar. I don't think there are any more questions coming in. But lastly, I think we missed out on one slide. Could you give us the perks of corporate law? I think one of the slides that we missed out on. If we could quickly look
Yeah,
at the
yeah,
perks of
yeah,
doing
yeah, yeah,
corporate law.
yeah. See, in the beginning, when you are starting your career, don't think in terms of money alone. This is the same thing I would say. There is no upper limit for what you can earn. Okay. And as I told you in the beginning also, you are in a profession wherein this starting and growth you may find that is a bit deterred. But then when you reach that particular point after 40 or 50, you'll notice that there is nothing like that. This is a profession which goes on paying. The more experience you have, the more earnings you have. Now you may become 70 or 80, you may not be able to speak, you may not be able to appear in a court, but your client will insist that you do it for him. This is the kind of profession that you have because of the faith that he has seen you doing things for a very long time. So the maximum that you can compare your profession with another profession would be the profession of medicine, wherein you don't go to a new doctor at all. You go only by references. So this is a profession wherein it takes time to get established. But when you get established, there's nothing like that. But the thing is, the question is of only patience and time. And if you find that in the beginning the earning is very less, you can think in terms of alternative earnings. Now the alternative earnings can be through teaching or writing articles or helping other students. All those things can come in to support you, to rescue you. So I think that you should not judge your performance just by comparing your profession with some other profession. That person is, my friend is earning this much per month, and I'm earning only this much. They will not compare because the professions are entirely different. The emphasis is entirely different. So there's no upper limit to it. But I personally feel that at least 5 years of good exposure is required. At least 5 years. Good exposure should be there because it's a very big area. You need to understand, if you have an assignment or a client walking into your office, you need to know what all implications can be there of that particular decision that you are advising him upon. That is the main thing, because no one particular decision can be isolated in the corporate world. If you are taking decision A, there may be areas which are P, Q, R, X, Y, Z. There are so many areas which may get impacted because of the decision. That angle and that analysis has to be there. For that, you need a lot of exposure. Learning is essential. You have to learn a lot day in, day out. A person who is 20 or 40 is also learning. A person who is in 70 and 80 is also learning. And don't compare yourself and think that, okay, I could learn only this much, someone else is doing better. That is not the case. Whatever you learn is going to be less. It's a very big ocean. Whatever you gather all through your life, you'll be filling only a few barrels of water. Rest of it is still, the ocean is going to be there. So don't get dejected just by thinking that I am not able to do this, someone else is doing. So you are doing your job. Today you are doing better than what you did yesterday. So you have learned all the way. So you have to think in those terms. And this is sufficient to earn. Earning comes in with your skill set. If you have a skill set and you work on it, you will definitely succeed. There's no what do you call dispute over there at all. Cannot be a dispute over there.
Okay, ma'am. Thank you. That was a wonderful analogy, the way you put it. Finally, our last question, which we'll address today, is again from Ujwal Gupta, who asks, can we establish a firm of all professionals, that is lawyers, CA or CSs, and CWAs?
Yes, you can do. Possibly in paper, some of the institute may not help you, but you can definitely have it. That is how practices run. If you ask me, that is how practice. That is, you have understood what is to be done. That is what I would say, because you cannot be everywhere. You
Yeah.
cannot have different avatars. Somewhere you are singing, somewhere you are dancing, in other place you are studying. All everything cannot go together. So somewhere you have to delegate, and delegation is something which you have to learn, even if it is within your firm, within your firm. Suppose if you're starting a firm today, you need to have a team. After some time, everybody realizes that you need to have people supporting you. Now, be it your own subordinate or your own other law professionals who are joining you as law, that is juniors, you are delegating to them also. The same way there has to be sharing. So if you have a group of people wherein you can share your work like this, it is the best possible way of doing things. Why? Because it's a win-win situation for them and as well as you. And the thing is that expertise pours in. Lot of expert opinions and analysis will come in over there. So best possible way of an issue can be addressed, or a matter which comes to you as a group can be addressed in a best possible way. Because what happens is that if I concentrate on secretarial aspect, I won't be able to grow in GST. If I am concentrating on GST, I won't be able to do this. So there are so many aspects which are, they fight with each other, and you have only 24 hours a day. So the same client, that's what I said when I said that when a client walks into your office, he wants all the services under the same roof. So this is something that you have to realize how to make it happen for him so that he stays with you, because you have whatever is required you have, whether you are doing it personally or do you are making someone else to do. That is the same thing. He is getting the services from the same roof. And he is also more comfortable. He has only one single contact point, that is you, and you can handle other people as well. So it's a win-win situation. That's the best way of doing things. If you have understood this, you are already halfway to becoming a professional, successful professional.
Okay.
That's the best thing that is to be understood.
Yeah. Okay. Thank you, ma'am. Thank you. I think at this point we will stop the Q&A session. If those have missed out on certain questions, or you still have questions that you're not comfortable discussing over a public forum, please feel free to send an email to Sowmya ma'am, as the details that we have shown in the first slide. Please get in touch with Sowmya ma'am if you have any doubts, if you have any queries, or any other, if you just want to talk as well. So thank you, ma'am. From Lawyered, we'd like to thank you for giving us 1.5 hours of your time and your inputs. We really appreciate
And I
it.
hope it was helpful. I hope it was helpful for
I'm
everybody.
from my side, at least it was very good. Thank you very much, ma'am.
Thank you so much.
That's all. Thank you very much. Thank you,
And
everyone,
thanks
for
a lot
joining.
for your patience as well.
Absolutely, no problem, ma'am. Thank you very much.
Okay. Thank you so much.
Yeah.
Thank you so much.
Please fill in the attendance sheet before you leave. Otherwise, you will not get marked attendance for this webinar. And thank you from the side of Lawyered. Bye
Yeah,
bye.
yeah. Thank you. Thank you so much. Thank you so much. Can I leave now?
Yes, of course.
Yeah. Thank